Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a great real estate story sent to me by Chris, and this is fascinating. Hang in there. I know, generally speaking, a story about real estate taxes and exemptions wouldn't be that interesting, but this one is, because it shows the lengths people will go to try to get tax exemptions, and also how courts can get bogged down in fighting over words to the point where you think they might actually need an Oxford English dictionary to figure something out. Out of the Tampa Bay Times, a Tampa couple set up a tent on the front lawn of the house that they're having built in an attempt to get that property then declared their homestead for tax purposes. But the tax people didn't like it, so they went to court, and they're still fighting. Several winters ago, people driving by one particular home under construction in South Tampa saw a tent pitched in the yard. Now, the house, when it's finished, is going to be a $1 million house, so this does seem to be a little incongruous. L. Lowry Baldwin and his wife Jennifer camped on the property in an attempt to show that it was their permanent residence eligible for homestead exemption, even though it was not finished yet. This is going on in Hillsborough County, and the property appraiser's office did not agree with them, denied the exemption for 2015, and so now they're fighting over tens of thousands of dollars in taxes that they were forced to pay in later years. Now, the couple appealed that first hearing, and that then worked its way into a legal battle that wound up in circuit court and then the Second District Court of Appeal. This is a Florida state court system. Lawyers and judges have been consulting dictionaries as well as legal cases and fighting over the words permanent and residence and what those words mean. Now they are attempting to get the Florida Supreme Court to hear the case, and the Baldwins really want a precedent-setting outcome that they say could help others who encounter unexpected delays in moving from one home to another. Baldwin said, we are fighting more for principle than actual dollars. We've spent far more on attorney's fees than we're going to save in taxes. So the Baldwins actually are well known in the area. They have an insurance agency, and they used to live in a house overlooking Tampa Bay in the Belmar Shores neighborhood north of Gandy Boulevard. In 2013, they sold their house for $3.475 million, and they paid $1.5 for a smaller house 2 doors away, and they're going to tear that one down and build a new home on the lot. While that new house was under construction, they rented a condo and were living in a condo. Now, here's the deal. People in Florida, residents of Florida, are entitled to up to $50,000 off the taxable value of their homes for purposes of determining property taxes. Annual increases in assessments are capped at 3%, and under the Save Our Homes Amendment, owners are allowed to transfer some of their tax cap savings from their previous home if they move. However, they must have received a homestead exemption as of January 1st of either of the two immediately preceding years. And a lot of states have got rules on this, that your primary residence will be taxed differently than a second or third or fourth home you own, okay? Yeah, these are not problems many of us have, but theoretically you could, okay? But the primary residence, okay, and that gets a certain kind of tax treatment different than these other things you own. And many states, Michigan has the same thing, that as long as you are maintaining that residence, the amount the taxes can go up from year to year is capped. And a couple of things can happen. So for instance, when you go to sell the house and someone else moves into it, they might get taxed at a higher rate simply because it's there, and then it gets capped for them from that point forward. But there can be a big jump when it changes hands. That's one example. Well, here the point is they go, we have this house here. This is our residence, and then we're going to move to this house here. And they want to be able to bring along a tax advantage. But of course, the problem is that they moved into a condo in between these two homes. And so that's where all of this happens. So the Baldwins, because they sold their own house, did not claim an exemption in 2014, but hoped to claim an exemption by January 1st, 2015, which would have qualified them for a homestead exemption and some of the benefits from that Save Our Homes amendment. Well, they ran into delays with their contractor. Jennifer Baldwin told the Tampa Bay Times, and they were unable to physically occupy the house by January 1st, 2015. So the couple then pitched a tent in the yard and slept there 2 nights. And they said that they did that to show that the property was legally theirs, which, okay, here's the deal. No one's disputing the property is yours. People are disputing whether or not you were occupying the property. Lowry said, that's the husband, said that they were very comfortable sleeping outdoors. He says, we recreate a lot out of doors. And so he said that they also changed their driver's licenses and their voter registration cards, all of this stuff to the address. So that would be their property. And then the couple moved into the house in June of 2015. After obtaining a final certificate of occupancy the following January, they applied for a homestead exemption and the Save Our Homes benefits for the 2015 tax year. The appraiser's office denied their application on the grounds that the property was not their homestead as of January 1, 2015. And this is one of the things that a lot of these departments will do. They'll simply go, oh, when was a certificate of occupancy issued? Because prior to that, you were not legally allowed to occupy that as a homestead. You can own it, but without the COA, you are not legally allowed to reside there. So the fact that you pitched a tent there, unless you're claiming exemption on your tent, doesn't make any sense. The Baldwins petitioned the county's Value Adjustment Board, which ruled in the appraiser's favor. The couple then filed a suit, and they said that they should be allowed to get the exemption because they had an intent to use it as their permanent residence. The appraiser countered that to claim it as a homestead, they had to physically occupy it because, let's be honest here, they were living in a condo. They were renting the condo, but they were living in a condo. So the Baldwins lost in circuit court. They then appealed. The appeals court judges first looked at the constitutional provisions on homestead exemption, which say in part that an owner who maintains thereon their permanent residence shall be exempt from taxation. So then the question is, what does maintain mean? And what does continue in possession of and care for mean? And you know, people often talk to me about Black's Law Dictionary or dictionary meanings of words, and many statutes contain their own definitions. So if you want to know what a motor vehicle is in Michigan under the law, the Motor Vehicle Code has a definition. So here's what motor vehicle is. A motor vehicle is, and it has a definition. Here's what a road is. Here's what a highway is. It tells you these things. And so if a statute contains its own definitions, you go with those, okay? But statutes don't define everything because some common words don't need definition. The in this statute means in this statute means, statute in this statute means. No, they don't do that, okay? So when they use common words, then you do look for dictionaries. And so, for instance, when they were wondering what the word maintain means, it wasn't defined, okay? But so they then go to dictionaries. The funny thing is they go to a Black's Law Dictionary and an American Heritage Dictionary, meaning that Black's doesn't, in this situation, have any more weight than any other dictionary, which I know is sad news for the sovereigns in the audience, but all three of you will have to buy that someday, that Black's Law Dictionary does not trump other dictionaries as a verb. The court then consulted Black's Law Dictionary for definition of maintain. Black's said it means to continue in possession of and care for property. American Heritage Dictionary agreed, adding that to maintain is to keep in an existing state. Based on those and the definition of permanent, which is not expected to change in status, condition, or place, the court found that the Baldwins couldn't possess or care for their permanent residence until it actually existed. That's what we call a reality check. And it didn't exist until it was finished in July of 2015. Because the couple had not established it as their homestead as of January 1st, 2015, they were not entitled to the exemption or the Save Our Homes benefit for the 2015 tax year, the judges said. Now, the attorney who represents the couple thinks they have a strong case if they get in front of the Florida Supreme Court because he says that this law is not applied uniformly throughout the state of Florida. He says, for instance, if the Baldwins had been in Dade County, they would have gotten the exemption and been entitled to the portability of the Save Our Homes advantage. He also says They were building a new house. They considered it their permanent residence. And importantly, they didn't own any other property in Florida that could have been a homestead. But of course, they were renting a condominium they were living in. And that was where they were living. And a homestead thing has to do with where you're living. Otherwise, you're going to lose the actual meaning of that. You know, I'm renting here, but I consider that my homestead. You know, or I'm building something down the road that will be my homestead, so it's now my homestead. Again, you're stretching the definition of what a homestead is. After the Baldwins moved in, the appraiser's office approved their application for homestead exemption for 2016. The house is currently assessed at $2.15 million, and the couple paid $41,000 in property taxes this year. The loss of portability means that the Baldwins now pay about $5,000 a year or more than they would have otherwise. Robert Stern, a Tampa real estate lawyer not connected to the case, said he admires what he calls the Baldwins' creativity in trying to get all of the tax benefits they can. But of course, you know, attorneys, we can admire a creative argument without saying it makes sense. A bill that would extend the time that owners have to apply for a homestead exemption and portability has been introduced in the legislature. The Hillsborough Appraiser's Office is supporting it, although Will Shepard, the general counsel, said he doesn't expect any change in the requirement that an owner must be occupying a permanent residence on January 1 of a given year. He said it's a slippery slope. If it's not January 1, is it okay for it to be 9 months, 10 months? I think there's a reason you have to be there on January 1. So the wife, Jennifer Baldwin, says she thinks she and her husband met the spirit of the law by tenting on their property for 2 days in the year in which they want the tax exemption. I'm skeptical, but we'll see what the Florida Supreme Court does if they take this case up. If they don't, then the couple is where they are right now. That is, they've got a beautiful house with slightly higher tax payments and the wonderful memories they had of camping on their own property for 2 days in Tampa. So there you go. Thanks for the story, Chris. Questions, comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Bazinga!